The Hindu Adoption. ACT. 1. Short title and extent. 1. This Act may be called the Hindu Adoptions and Maintenance Act, 1956. 2. It extends to the whole of India, except the state of Jammu and Kashmir. 2. Application of Act. 1. This Act applies a. To any person who is a Hindu by religion in any of its forms or developments, including a Virashaiva, a Lingayat or a follower of the Brahmo, Prarthana or Arya Samaj. B. To any person who is a Buddhist, Jaina or Sikh by religion, and C. To any other person who is not a Muslim, Christian, Parsi or Jew by religion, unless it is proved that any such person would not have been governed by the Hindu law or by any custom or usage as part of that law in respect of any of the matters dealt with herein if this Act had not been passed. 3. Definitions in this Act, unless the context otherwise requires. A. The expressions custom and usage signify any rule which, having been continuously and uniformly observed for a long time, has obtained the force of law among Hindus in any local area, tribe, community, group or family, provided that the rule is certain and not unreasonable or opposed to public policy, and provided further that, in the case of a rule applicable only to a family, it has not been discontinued by the family. B. Maintenance includes, I. In all cases, provision for food, clothing, residence, education and medical attendance and treatment. 2. In the case of an unmarried daughter, also the reasonable expenses of an incident to her marriage. C. Minor means a person who has not completed his or her age of 18 years. 4. Overriding effect of Act. Save as otherwise expressly provided in this Act. A. Any text, rule or interpretation of Hindu law or any custom or usage as part of that law in force immediately before the commencement of this Act shall cease to have effect with respect to any matter for which provision is made in this Act. B. Any other law in force immediately before the commencement of this Act shall cease to apply to Hindus, in so far as it is inconsistent with any of the provisions contained in this Act. Adoption. 5. Adoptions to be regulated by this chapter. 1. No adoption shall be made after the commencement of this Act by or to a Hindu except in accordance with the provisions contained in this chapter, and any adoption made in contravention of the said provisions shall be void. 2. An adoption which is void shall neither create any rights in the adoptive family in favor of any person which he or she could not have acquired except by reason of the adoption, nor destroy the rights of any person in the family of his or her birth. 6. Requisites of a valid adoption. No adoption shall be valid unless I. The person adopting has the capacity, and also the right, to take an adoption. 2. The person giving an adoption has the capacity to do so. 3. The person adopted is capable of being taken in adoption, and 4. The adoption is made in compliance with the other conditions mentioned in this chapter. 7. Capacity of a male Hindu to take in adoption. Any male Hindu who is of sound mind and is not a minor has the capacity to take son or a daughter in adoption, provided that, if he has a wife living, he shall not adopt except with the consent of his wife, unless the wife has completely and finally renounced the word or has ceased to be a Hindu or has been declared by a court of competent jurisdiction to be of unsound mind. 8. Capacity of a female Hindu to take in adoption. Any female Hindu who is of sound mind and is not a minor has the capacity to take a son or daughter in adoption, provided that, if she has a husband living, she shall not adopt a son or daughter except with the consent of her husband unless the husband has completely and finally renounced the world or has ceased to be a Hindu or has been declared by a court of competent jurisdiction to be of unsound mind. 9. Persons capable of giving in adoption. 1. No person except the father or mother or the guardian of a child shall have the capacity to give the child in adoption. 2. Subject to the provisions of subsection 3, the father or the mother, if alive, shall have equal right to give a son or daughter in adoption, provided that such right shall not be exercised by either of them save with the consent of the other unless one of them has completely and finally renounced the world or has ceased to be a Hindu or has been declared by a court of competent jurisdiction to be of unsound mind. 4. where both the father and mother are dead or have completely and finally renounced the world or have abandoned the child or have been declared by a court of competent jurisdiction to be of unsound mind or where the parentage of the child is not known, the guardian of the child may give the child in adoption with the previous permission of the court to any person including the guardian himself. 10. Persons who may be adopted. No person shall be capable of being taken in adoption unless the following conditions are fulfilled, namely, I. He or she is a Hindu. 2. He or she has not already been adopted. 3. He or she has not been married, unless there is a custom or usage applicable to the parties which permits persons who are married being taken in adoption. 4. He or she has not completed the age of 15 years, unless there is a custom or usage applicable to the parties which permits persons who have completed the age of 15 years being taken in adoption. 11. Other conditions for a valid adoption. In every adoption, the following conditions must be complied with. I. If the adoption is of a son, the adoptive father or mother by whom the adoption is made must not have a Hindu son's son or son's son, whether by legitimate blood relationship or by adoption, living at the time of adoption. 2. If the adoption is of a daughter, the adoptive father or mother by whom the adoption is made must not have a Hindu daughter or son's daughter, whether by legitimate blood relationship or by adoption, living at the time of adoption. 3. If the adoption is by a male and the person to be adopted is a female, the adoptive father is at least 21 years older than the person to be adopted. 4. If the adoption is by a female and the person to be adopted is a male, the adoptive mother is at least 21 years older than the person to be adopted. The same child may not be adopted simultaneously by two or more persons. 12. Effects of adoption. An adopted child shall be deemed to be the child of his or her adoptive father or mother for all purposes with effect from the date of the adoption, and from such date all the ties of the child in the family of his or her birth shall be deemed to be severed and replaced by those created by the adoption in the adoptive family, provided that a. The child cannot marry any person whom he or she could not have married if he or she had continued in the family of his or her birth. B. Any property which vested in the adopted child before the adoption shall continue to vest in such person subject to the obligations, if any, attaching to the ownership of such property, including the obligation to maintain relatives in the family of his or her birth. C. The adopted child shall not divest any person of any estate which vested in him or her before the adoption. 13. Right of adoptive parents to dispose of their properties. Subject to any agreement to the contrary, an adoption does not deprive the adoptive father or mother of the power to dispose of his or her property by transfer inter vivos or by will. 14. Determination of adoptive mother in certain cases. 1. Where a Hindu who has a wife living adopts a child, she shall be deemed to be the adoptive mother. 2. Where an adoption has been made with the consent of more than one wife, the senior most in marriage among them shall be deemed to be the adoptive mother and the others to be stepmothers. 3. Where a widower or a bachelor adopts a child, any wife whom he subsequently marries shall be deemed to be the stepmother of the adopted child. 4. Where a widow or an unmarried woman adopts a child, any husband whom she marries subsequently shall be deemed to be the stepfather of the adopted child. 15. Valid adoption not to be cancelled. No adoption which has been validly made can be cancelled by the adoptive father or mother or any other person, nor can the adopted child renounce his or her status as such and return to the family of his or her birth. 16. Presumption as to registered documents relating to adoption. Never any document registered under any law for the time being in force is produced before any court purporting to record an adoption made and is signed by the person giving and the person taking the child in adoption. The court shall presume that the adoption has been made in compliance with the provisions of this act unless and until it is disproved. 17. Prohibition of certain payments. 1. No person shall receive or agree to receive any payment or other reward in consideration of the adoption of any person, and no person shall make or give or agree to make or give to any other person any payment or reward the receipt of which is prohibited by this section. 2. If any person contravenes the provisions of subsection 1, he shall be punishable with imprisonment which may extend to 6 months, or with fine, or with both. 3. No prosecution under this section shall be instituted without the previous sanction of the state government or an officer authorized by the state government in this behalf. Conclusion. The slides explains about the Hindu Adoption Act 5 to 17 sections.